Have you entered, sir?
Yeah. But everything I'm seeing you, I'm seeing others, but those buttons, those are not there. So neither I can.
Sir, would you mind going logging out and logging in, please?
Okay.
I think that might. Ji. Manas Chaudhary sir could not get in, so he logged out. He will log in. Give him access. Huh? Okay. No, it's okay. I'm okay. Are we live yet?
I think it's fine now.
So we're good to go.
Yeah, is my voice is fine?
Sir, clear and loud.
And video?
Very clear.
Okay, great.
Sir, thank you, sir. So can I check on Mr. Chairman, sir, Mr. Mofizul Islam,
Yes.
sir? Sir,
Yes, I can hear you clearly. Thank you.
Thank you, sir. Fine, by you can hear us?
Yeah.
I can hear you quite well.
Okay, thank you. We will have Dr. Enamul, Professor Dr. Enamul, sir, in a minute. And Ms. Nihat Kabir Appa will join maybe 20 minutes later. Aslam, sir, you can hear me?
Yes, of course. I can hear you.
Sir, shall we start?
Yes, go ahead.
Okay. Good evening, dear and respected guests, and our esteemed panelists, and the honorable chair of this panel. On behalf of Bangladesh IP Forum and Bangladesh IP Academy, a very warm welcome to today's webinar titled Competition Law Regime in Bangladesh, hosted by Bangladesh Intellectual Property Forum and Bangladesh Intellectual Property Academy. To give a brief background about the organizers, which is Bangladesh Intellectual Property Forum, which is a not-for-profit entity that promotes intellectual property and does capacity building advocacy work for the protection and enforcement of intellectual property rights within Bangladesh. And today's webinar, we have partnered with the Business Standard, one of the leading daily newspaper. They're the media partner. We also have JESAP Bangladesh, an international Law Students Association, Bangladesh chapter, and Old Bailey Chambers as the strategic partners. Before we start, I'd like to express my sincere appreciation to all our esteemed speakers and the team who helped us to organize this webinar, and the guests who are participating today. We have more than 15 universities joined us as a guest today, respected teachers from the universities and beloved students from those universities. They have joined. So we are very happy to have you here. To give you a little background about the core topic of today's discussion, which is the competition law that aims to promote competition in a given market, that regulates anti-competitive behaviors of companies. Competition law is also known as the antitrust law in different parts of the world, including US. So competition law mainly does things. It has three core elements, which prohibits agreements or practices that restrict free trade in the market and also prohibit cartels. It also prohibits abuse of dominant position in a market or anti-competitive practices. And third, it regulates or control mergers and acquisitions of large companies that may have an anti-competitive impact in the market. However, by and large, competition law protects the consumer's interest and welfare and also ensures a level playing field for businesses so that they can compete in the market. In this context, in the context of Bangladesh, we've had Monopolies and Restrictive Trade Practices Act from 1969, which had the object to control or prohibit monopolistic behavior in the market and restrict trade practices. In addition, the freedom from exploitation, the term is actually enshrined from the Article 10 of our Constitution of Bangladesh, which ensures the attainment of a just and egalitarian society free from any exploitation. So in 2012, Bangladesh adopted the Competition Act, which is called the Competition Act of 2012. And with that act, the Monopolies and Restrictive Trade Practices Act 1969 was repealed, and Bangladesh Competition Commission, BCC, was established. The commission is actually headed by a chairman. The chairperson of the commission is the honorable chair of today's webinar, and we are very happy to have him here, and it's our pleasure to have you here, sir. Very welcome to you. So under Section 5 of the Competition Act, the commission is formed. So at the preamble of the Competition Act, it states that Competition Act promotes, ensures, and sustains congenial atmosphere for the competition in trade and also prevent and control and eradicate the collusion, monopoly, and oligopoly, or combination or abuse of dominant position or activities adverse to competition in the market. Once again, we feel very privileged and are humbled by the graceful presence of the panel speakers in today's webinar. If I may introduce, as per the order, Mr. Manas Kumar Chaudhary, Partner, Competition Law Practice, Khetan & Co, India. Mr. A.K.M. Fahim Masroor, CEO, jobs.com, Bangladesh. Mr. Aslam Hayat, Partner, Hayat & Noorwala, Pakistan. Dr. A.K. Anamul Haq, Professor of Economics, East West University, Bangladesh. Barrister Nihat Kabir, Senior Partner, Syed Istiaq Ahmed and Associates, and also President, Metropolitan Chambers of Commerce and Industries. Mr. Evan Williams, Attorney of the U.S. Department of Justice, U.S. And today's chair of the webinar, Mr. M.D. Mofizul Islam, Chairperson, Bangladesh Competition Commission. On a personal note, it is a moment of pride for me too, that actually today I am moderating three of my mentors, Mr. Aslam Hayat, from whom I learned the ABC of technology laws back in 2007 to 2010. And it was a great learning experience for me, sir. And very good to see you after 11 years today. And then Mr. Manas Kumar Chaudhary, he taught me competition law back in 2010. and also Dr. Professor Enamul Haq sir. He taught me how economics for competition law works. Today, we are also joined by, as I said before, some distinguished guests as the participants of this webinar, which include faculty members and students from more than 15 universities, CXOs and colleagues from very well-reputed corporate entities, including Banglalink, Robi, if I humbly mention their name, it's my privilege, Japan Tobacco Industries, Food Panda, and also some respected judges from our judiciary and colleagues from the from our legal fraternity. Now, please allow me to introduce to you our first speaker today, Mr. Manas Kumar Chaudhary, partner, competition law practice, Khetan & Co, India. To give a brief background about Mr. Chaudhary. Mr. Chaudhary is a partner and co-head of the competition practice at Khetan & Co, and he has been recognized as a Band 1 lawyer by Chambers and Partners consecutively for last few years. He's also been named as the leading competition lawyer by the international who's who of competition lawyers and economists. Mr. Chaudhary has over 28 years of legal experience in diverse fields of legal practice. He was previously a judge of West Bengal, a legal advisor with the government of India, and has more than 15 years of competition law experience, having served as a key officer at both at the CCI and the predecessor organization, namely the MRTPC Commission. It's a great pleasure, sir, to have you here among us, and I would like to welcome you and start your speech. Sir, before you start, if I may just for the respected participants today, that after the chairperson has delivered his speech, we'll have a question and answer series. So if you have any questions, please do feel free to direct them to me. And with your questions, it would be nice if you could indicate to which panelist you are referring the question to. And then we'll get back to the esteemed panelists with those questions for the answers. Over to you, sir, Mr. Manas Kumar Chaudhary.
Thank you, Misbah. Good evening and good morning to my friend in the US. It's a great honor to speak in today's webinar, which is being chaired by none other than Mr. Muhammad Mufizul Islam, the Honorable Chairperson of Bangladesh Competition Commission. Thank you very much, sir, for gracing the occasion. I also thank Hamidul Misbah and his other organizing committee members who tirelessly, with their efforts, have helped us to come together and share our thoughts today. It would be more of a experience which we have gathered in the last several years of our association with the legal profession and in particular the Competition Act. I personally send my personal greetings from India to my fellow panelists, Mr. Fahim Masroor, Mr. Aslam Hayat from Pakistan, Professor Enamul Haq, who I have worked with in 2007-8 when we were actually working in a World Bank project for the Bangladesh competition law, very initial days. And I was very, very fondly remembering his graceful presence and very warm hospitality. Professor Enamul Haq, it was really wonderful to remember those days and very happy to meet you online today. Madam Nihat Kabir, our other panelist, and our friends from the US, Mr. Ivan Williams. In my presentation, what I'd like to do, because time is the constraint, but I would like to share what I have experienced in my last over 20 years. I started my journey. I would consider that by default, I started my journey because at that time in 2000, I was in West Bengal Judicial Services. So I came back to Delhi through this competitive exams and joined MRTP Commission. And at that point of time, India was in the cusp of deciding about whether or not to have this new competition law in India, since the MRTP Act has almost lost its utility with the kind of economic liberalization India adopted in 1991. Then also India signed the WTO agreement in January 1995. All of that were becoming a contradiction to MRTP Act. And that was the time when I joined the MRTP Commission, and I would still consider that as by default, I was roped into the entire journey of competition law enactment, process of enactment, passing of the legislation to writing of the procedure regulations, all were somehow came on my lap, and I started learning this subject, which is still continuing. I cannot really call myself to be a competition expert, because when I meet my counterparts in the US and EU, I find them they're so humble. For 35 years of practice, they still say that they're in the learning curve, because competition law is all about dynamic markets. So since the markets keeps changing, for example, the digital market of today, nobody had imagined in 1990 that there would be so much of issues in a digital market. How do you really apply that to a traditional market? So it's still a work in progress for all of us. So what I would like to cover, I would like to give a conceptual issues which I have gathered in my 20 plus years of being associated with this practice in India. And then I would like to really walk you through as to how I have read the Bangladesh Competition Act when I read it along with the Indian Competition Act, and especially while we were engaged in 2007-8 with the Commerce and Industry Ministry of Bangladesh to give certain kind of a nuanced view as to what the bill of Bangladesh competition law look like. So how it has changed over the years, and ultimately what has finally come as a statute. And then finally, the journey of India from May of 2009 until today. So in that three buckets, I would like to just first give a competition assessment, competition overview, competition economics law mix. So competition law, what I have learned from various legislations, not defined per se in any competition act, not even in Indian Competition Act, but we have derived this from a World Bank 1999 report, which broadly defined competition, which says a situation in a market. Every word is very important. A situation in a market, when I say market, I am talking about a market which can be relevant market, which can be relevant product market, which can be relevant geographic market, but broadly a market. A situation in a market in which firms, when I say firms, it can be undertaking, it can be enterprise, whatever your law defines firms, in which firms or sellers, that is more important, independently strive for buyers' patronage in order to achieve a particular business objective, for example, profits, sales, or market share. So this definition of World Bank is very handy. It actually talks about quite a number of things. Sellers and buyers, sellers and sellers, independently striving buyers' patronage, because then I go back to 1776, Wealth of Nations by Adam Smith. He says that businessmen very seldom meet, but whenever they meet, they end up conspiring against the consumers. So that particular objective of Wealth of Nation by the great Adam Smith of 1776 still hold good in competition analysis. So what I am saying here is that profit is the ultimate objective of a business. Market share, gaining market share is another objective of a business. And in the process, whatever happens, that delta becomes anti-competitive. So what I would like to appreciate from this definition is that agreements is the core area of competition law. Whenever I am saying agreements, I'm talking about commercial agreements between independent companies, independent enterprises, independent undertakings. They can be in the same level of business, which is horizontal agreement. They can be in the vertical business, that is the sellers, the distributors, the retailers, and end consumers. And at times there can be very healthy combination of businesses which can be mergers. And generally in competition economics, those are called pro-competitive agreements. But again, for a merger also, there needs to be a binding agreement between the buyer and the seller, acquirer and the target, whatever language you may like to call. But agreements is the ultimate core objective of a competition agency to look into, which must be independent, must have been entered into by independent enterprises. And that is what the subject matter of the Competition Act primarily is. However, the competition law in most jurisdictions also define what are the safe harbors. Every agreement is not anti-competitive. So obviously we lawyers try to find what are the justifications we can give for any alleged breach of a Competition Act. And those are in competition economics are called safe harbors. So in 1990, we had about 32 competition agencies. I'm talking about 1990. Now in 2021, that is in about 30 years plus, there are about 125 competition agencies. So what could be the reason? The reason may be what we have understood. One of the reasons was that signing of the World Trade Organization treaty by 35 sovereign countries. And one of the conditions of that WTO treaty was that free trade amongst the signatory countries. The moment you agree to an international treaty where you are subjected to a free trade, obviously the economies of the signatory countries being not the similar in level, obviously you need to protect your domestic industry. And that is the time the call was given to all sovereign countries. Do you really want to protect by way of some legislation your domestic industry? And that is the time the idea came for the enactment of competition legislation across globe. And that is the reason I think 75% of the competition agencies have all had come up during this period. What are the basic objectives? To boost competition between domestic business, enhancing cross-border competitiveness. When I say enhancing cross-border competitiveness, what I mean that you may raise your standard of doing business fairly and you become so competitive in the market that you then try to reach out to your international competition and you compete in international market also. The moment you compete, you are definitely going to generate economic efficiencies and which would ultimately benefit your company, means your country of origin. To promote foreign trade and regulate imports and exports, to improve the technology and foreign capital, to develop global market of a country, to reduce debt burden of a country, undertaking and economies. These are the broad general objectives which also form part of the Indian competition enactment at that time, which is typically a committee was constituted under the name of Raghavan Committee. And that Raghavan Committee has in fact taken clues from various jurisdictions and had brought down these at the level of a micro level for the parliament to really go out and take evidence from various stakeholders. I would just like to add one very interesting feature of the Indian Competition Agency's development story. In 1999, Raghavan Committee, that is a committee by the name of the chairman of the committee, it had come out with a report. And when it was placed before the government decided to place it by way of some kind of a bill before the parliament, and parliament decided to have a select committee for initiating the process of taking evidence from various stakeholders, which would include the business, the industry, the professors, the professionals, the lawyers, the chartered accountants, you name a professional who was not there and did not participate in the process. It went for about a year, and the previous president of India, late Mr. Pranab Mukherjee, he was at that time leader of the opposition in the Rajya Sabha. He was made the chairperson to actually take evidence and write the report. And that was a very consultative process where the industry's concerns were taken into consideration by the government. So what does this entire process came up that ultimately the committee suggested that we must give up the Monopolies and Restricted Trade Practices Act because it has completely outlived the utility after India has adopted the economic liberalization. India signed the WTO treaty, and also the international competition law is very, very different than what the MRTP Act was talking about. So those were the basic areas which actually prompted the parliament to pass the act. It was passed on 13th January 2003, and thereafter it came into being. So I would definitely walk you through to the exact implementation of the Competition Act in India. Before that, I would just like to talk a bit about Bangladesh Competition Act. I have just selected a few sections because that has really attracted my attention to discuss for today. Section 8, which talks about the commission would be investigator and the adjudicator. And it would also enjoy suo motu powers. That means on its own motion, it can also initiate any inquiry. I have not found that whether there is an essential condition for the commission to have a judicial member. So section 8 is talking about investigator, adjudicator, suo motu powers in one body, that is commission. Section 11 talks about the nature and the characteristics of the commission. It says it would be a civil court under the Civil Procedure Code 1908. And at the same time, it would decide complaints. Now this word complaints in law means somebody is aggrieved by some other party's conduct, behavior, which has caused grievances to this complainant. But at the same time, the moment it is a complaint, there must be opposite party, and it becomes a kind of a bipolar dispute in interpretation of law. But when I read section 11, there is also a mechanism where the commission will decide every matter by voting, with the presiding member enjoying second or a casting vote. Now this becomes little interesting for me as a student of law, that if an adjudicatory process is ending with a casting vote, it overlaps with some kind of a board meeting. So if there is an adjudicatory process, each member must be independently deciding the matter, and then the majority decision is the final decision of the adjudicatory process. But here the casting vote at times may be questionable on the ground of bias. That is one area as a student of law I thought I should highlight here in section 11. Insofar as section 15 is concerned, the anti-competitive practices in law has been written shall be deemed to be anti-competitive, which again in a legal interpretation means per se illegal. It's not a rule of reason kind of a situation. So with investigation and adjudication in one body with a voting kind of a situation, and if it is a per se illegal or deemed illegal, then obviously the risk for the business houses would be very, very high. Section 23 talks about the parties can come before the commission. Also, they can come through representatives. I believe that this representation may be inclusive of lawyers and advocates and other professionals. And then I go to section 24 to 30, which is very interesting for a practicing lawyer. That is, how does the commission really look into the appeal provision of the orders of the commission? So the appeal is before the government. Now, a very interesting interpretation can be given here. The commission is controlled by government, and commission is adjudicating, investigating, passing a final order, which is determining the rights and liabilities between the complainant and the respondent. And the appeal goes to the same government which actually administratively controls the commission. So this is an area which I thought I must highlight, which is not there in our law. Competition acts across the globe is a combination of business, economics, and law. But in the Bangladesh Competition Act, I have not been able to lay my hands on or look at, unless there are certain statutory regulations created later, what are the factors which can be relied upon as objective justification, economic justification, theories of harm, that if the theories of harm are not proved, then obviously, even if an adjudicatory process has taken place, the opposite party has a defense. And that defense would be more of an economic rather than legal. So those factors are not available in the law. Maybe perhaps the commission can regulate that by way of some statutory regulations. It remains to be seen how the jurisprudence would evolve when the commission starts functioning, because economic parameters, microeconomic parameters, Professor Inamul Haq would appreciate, would be very essential to justify a business, which prima facie may appear an anti-competitive business practice, but may not be so if an economic justification is given. And then finally, there is a criminal sanction for non-compliance. So it's a mix of a civil law, criminal law. There is a lot of deterrence. The positive side of whole enactment, to my mind, appears that the Parliament wanted expeditious disposal, and that is the reason they have created very less interference by the process of appeal or something. But if that goes very well, then it's wonderful. But if that is prevented by some constitutional writs, etc., then it might generate delays. So insofar as the last section of Bangladesh Act is concerned, there is, of course, we are talking about overseas anti-competitive practices. If they affect the Bangladesh market, then the Commission will have power to adjudicate those matters. These are typically in economics are called effects doctrine. The effects of an anti-competitive practice which is being indulged in an overseas jurisdiction, if it adversely affects another jurisdiction where it has not originated, then the Commission must have a right to look into remedying their local market problem. Coming back to quickly, Indian Competition Act, it started the journey on 20th May 2009, and as on today, it has 1,100 antitrust cases decided. When I say antitrust cases, I'm talking about cartels, bid riggings, resale price maintenance, refusal to deal, exclusivity of business dealings, and bid rigging. It has decided 800 plus merger controls, and very interestingly, almost all have been approved, barring only 6-7 which have been modified, but not a single has been rejected. And the Commission has a legal mandate to engage into competition advocacy. It has until now had about, I have taken this from the annual report of the CCI, about 800 plus advocacy events it had undertaken so far in the last 10-11 years. CCI is a very prominent member of the International Competition Network since 2003. It was also the co-chair of the merger committee of the International Competition Network. It hosted the 2008 annual Global ICN conference in New Delhi. The ICN typically allows the Commission to nominate non-governmental advisors, and they are typically taken from the legal fraternity. I am fortunate to be one of the NGAs of the CCI and had attended and participated in speeches, sessions in Portugal, in Porto, and also in New Delhi in 2018. Many of our legal colleagues are also part of these NGAs. They also keep traveling with the CCI for these programs. I'd also been invited by the chair CCI to be part of the BRICS conference in Moscow in 2019. So this interactive process with the CCI and the professionals continue unabated. The International Cooperation Agreement, which is an inherent part of the Competition Act of India, India entered with the International Cooperation Agreement with the Federal Anti-Monopoly Services of Russia on 16 December 2011. It entered with the US FTC DOJ on 27 September 2012, then with Australian Competition and Consumer Commission on 3rd June 2013, then with the European Commission on 21st November 2013, then with Canadian Competition Bureau on 1st December 2014, and on 19th May 2006 with all the 5 countries of the BRICS. So this international cooperation with the ICN actually enables the CCI to really expand its scope to the boundaries beyond India, and in the process, vice versa, cross-border advocacy also helps us developing the competition law in India. What it has actually in sectors generally taken, most of the cases are entertainment, pharma, aviation, agriculture, construction, cement, sports, real estate, tire, sugar, all these usual competition law breaches which happen across the globe. CCI is also engaged with all of them. It has introduced a very interesting green channel route in August 2019 for merger control. So if the parties to the combination can show that there is no overlap in the horizontal market, in the vertical market, or in the complementary market, then the green channel route makes it a deemed approval. There is no competition assessment made. And until between August 19 and until now, 30 such notices have been approved without any objection by the CCI. CCI also indulges into regularly bringing out market study reports. It has brought out healthcare sector, e-commerce, pharmaceutical sector, telecom, and currently undertaking the private equity market study report. Most of these reports are in a consultative process, and we are invited to participate in all these sector market studies. And there are final seminars happen when the CCI announces the finalization of the sector report, and typically there is a fun fair, the minister opens, inaugurates those kinds of sector reports. It has also partnered with law schools, business schools, and regularly undertakes quite a number of research projects, moot courts with these professional institutions. The appeal process of the Competition Act is very, very interesting. We have got a specialized appellate tribunal, typically headed by a retired Supreme Court judge. It is independent of government, it is independent of CCI. It has got about 3 members, and all of them are judicial members. The appeal is to be preferred within 60 days from the order of the CCI, and then a final appeal before the Supreme Court of India on points of law from any orders of the appellate tribunal. So the Supreme Court has so far settled many jurisprudence with regard to cartel and abuse of dominance. So far, merger control has not really traveled to the appellate jurisdiction because all of the merger controls have been approved so far. So there has never been a cause of action for a grievance of any party. I think I stop here. I have taken a lot of time, and I'll be happy to take questions. Thank you very much.
So thank you so very much for the enlightening and very comprehensive analysis, where you have touched upon the law, Bangladeshi Competition Act, as well as the act in India, and also how they have shaped it up over the last 2 decades. So thank you so very much. We will come back to you with the questions afterwards. Now, over the last few years in Bangladesh, we've seen that number of concerns that have surfaced from the industry. So it could be the telecom industry, it could be the e-commerce and the basic commodity industry. So the industry players, they have raised their concerns that anti-competitive practices might be happening in Bangladesh market, and that needs to be looked into. So on that note, I would like to welcome our next speaker, Mr. AKM Fahim Masroor. Mr. Fahim Masroor is the CEO, bdjobs.com, and also another e-commerce platform, ajkerdeal.com. A very prominent e-commerce business person in Bangladesh. He is an IT business entrepreneur. He's been the president of BASIS, which is the largest industry association for IT entrepreneurs in Bangladesh. And he is the first person to start an e-commerce platform for advertising jobs called bdjobs.com. So I would like to invite Mr. Fahim Masroor to share his speech with us, and also puts the lights on, shades on some of the concerns that we've seen or heard over the last few years in Bangladesh with regard to competition law, abuse of dominance maybe, and other issues. Thank you. Fahim bhai, over to you.
Thank you. I think I am audible. Thanks.
You are.
Okay. Thanks, Barrister Misbah. First of all, it is probably one of the first such seminar that is held, particularly on the competition issues with both legal and industry experience perspective. So I really am grateful that you have taken this initiative. I am very happy that today we are actually, we have with us our Honorable Chairman of the Competition Commission. So that is a privilege for all of us. So I think I will be very brief. I actually have been hearing from Dr. Mr. Chaudhary on Indian experience and how the competition law has actually evolved, and also his perspective on Bangladesh Competition Act 2012. So I'm not a lawyer, of course. I would not be able to go into too much technicality on these things. I can just share my kind of very high level experience from the very industry perspective. And as Mr. Chaudhary has actually mentioned, that when it was the laws have been drafted, particularly it was the IT and digital space was very unknown. And what we have been kind of hearing in recent years, particularly in India also, there are a lot of kind of things going on, particularly with the advent of big multinational companies in tech fields, whether it is kind of Amazon or other players or Flipkart or Walmart. So what we have seen that even in a kind of business level, the local small entrepreneurs, the small retailers are actually creating a lot of political pressure on the government to actually protect their interest against these big multinationals. Because they are really afraid that these multinationals are actually taking the market away from them, and they are actually going to be the monopoly very soon, and would create a lot of disruption in the employment and entrepreneurship. So I think similar thing, there is every indication that similar kind of things are also kind of happening or going to happen very soon in Bangladesh, because what we have seen in recent years, that there are a lot of foreign capital that is actually coming in. Of course, as a country, the policy of the government is to encourage foreign investment, foreign direct investment and indirect investment. But sometimes there are kind of clashes or kind of clashes of interest or kind of these type of disruptions where a lot of small players who contribute, by the way, the largest amount of employment in the country, because all of us know today we have got the MCCI president with us, that the largest employment generator of the countries are not necessarily the biggest corporations. They are basically the small entities. So, and it is also kind of policy priority for the government to protect the employment as well, or generate enough employment for them as well. So what we have seen, particularly in the digital space, because I have been into the digital space, that there are two kind of anti-competitive practices are actually going on in recent few years. One is, of course, this what I have just mentioned about large multinational companies who are actually coming here and acquiring market share by price dumping, whether it is a product or whether it is a service, whether it's an e-commerce or a kind of ride-sharing service or food delivery service. What we have seen, a lot of price dumping are actually taking place. And I know that there are some kind of complaints also raised to Bangladesh Competition Commission, and in some of the cases, Competition Commission is also investigating in some of those. So there is this kind of price dumping going on at much and price subsidies also going on in this market. So it's a concern in general in the industry. At the same time, what we have seen also in recent times with regard to the digital space, that there are a lot of the cases where this price dumping is not necessarily done by a few kind of big foreign players who are kind of putting in huge amount of money in terms of capital. But interestingly, there is cases where money is being collected from the consumer and that money is being blocked for a good amount of time, something like 6 months or 9 months, and that money is actually being used to dump product pricing. So I'm not sure to what extent that actually falls into the purview of Competition Commission or falls into the purview of the central bank and other authorities, where this practice of like blocking customers' money and forcing them to kind of buy something. I guess there are technical issues that probably our honorable chairperson can actually explain or can share their view on this thing. But this is also an interesting phenomenon what we have seen in recent months, where few companies are actually kind of taking money from the customers and they are actually blocking the money for probably 6 months, 9 months, and in exchange or in the kind of alluring the customers for kind of taking the or offering the price or the product at a much below than market price, almost kind of 50 or 60% discount of the price. So that is actually creating a lot of disruption in the market, where the standard players are having it very difficult to kind of offer their regular price service, because you can't actually compete in a situation where some other players are actually offering it much below than the cost price. So this practice is actually happening, and what we are a little bit concerned that our regulators are not either very aware about that, or they are a little bit kind of confused what to do, how to do, because sometimes these kind of players can work or kind of can slip through the legal loopholes. So I think I would actually probably request the kind attention of our honorable chairman on this. So because that's why I say that we are very lucky to have honorable chairman Mr. Mofizul Islam sir. So who is actually, I know that they are already in some cases investigating on those things. So their perspective on that. The last point I would just try to say, or I can say that what I have understood from the reviewing the Competition Act, that even if the commission thinks that there are unfair practices or anti-competitive practices, the maximum the competition can probably do is to kind of fine the particular company. I'm not sure in India what are the cases, to what extent the Competition Commission can actually recommend other authorities, whether it is central bank or a kind of other Ministry of Commerce or National Board of Revenue, to kind of take other strict measures, because fining is something that lot of these players can actually be like, they can just put fine like taka 5 lakh or 10 lakh and they can just get away with it. So is fining the only remedial thing, or there should be other kind of punitive actions for this type of anti-competitive practices? So I will actually stop there, and I am really interested to know the other cases of other countries, and also learned panelists and our honorable chairman. Thanks a lot.
Thank you, Fahim Mashroor Bhai, for your valuable speech and actually sharing some of the concerns that we've heard or seen over the last few years in the industry, and mostly about the price dumping and some speculation about anti-competitive practices that might be going on, happening in the e-commerce sector. So we would definitely come back to you if there is any follow-up questions. Now we'd like to move to Mr. Aslam Hayat. Mr. Aslam Hayat is a very renowned telecom expert in the South Asian region. He's a ICT regulatory professional, and he's previously worked for Grameenphone in Bangladesh and lived 5 years in Bangladesh. And later on, he has moved to Fiji in a World Bank project. And then he has joined Telenor Pakistan in July 2013, where so Mr. Aslam Hayat has a LLM degree from King's College, London, both in telecom and IT law, as well as in competition law. He's been extensively working in this area, in the advising in the legal and regulatory stakeholder relationship matters in the telecom, internet, IT, and in the whole area. And he's got very good understanding and experience in the competition law area too. So for technology and competition law, they actually go hand in hand. And technology is expensive, need licenses. It's not very easy to entry into the market in the technology. So the possibility of distortion or aspect of competition in the technology industry, be it telecom, be it internet or ICT, is very much there. The relationship is very great. So I would like to invite Mr. Aslam Hayat to share his experience with regard to competition law, specifically, if possible, related to telecom and technology area, and ancillary matters there too. So over to you, sir.
Thank you, Mr. Bhai. It's a great honor and privilege to see a lot of old friends from Bangladesh. I've spent wonderful years and my family still miss Dhaka. So I'm sure once this lockdown is over, I would love to come over and meet all of you. Just a little bit more introduction. I have, in addition to what Mr. Bhai has said, I've also worked as Director Law in the Ministry of IT. And in that capacity, I also worked on the deregulation policies that happened back in 2003. And at that point in time, the competition framework, general competition framework was not there. So part of the responsibility I had was to introduce the competition framework for the telecom sector specifically. That was done both in the policy and amendment was made in the telecom legislation. At the same time, there was a discussion going on with the World Bank about framing a competition law in Pakistan. So I was also part of that discussion and had quite a few interactions with the World Bank team and then other people who were working on it. So Pakistan got its competition law in 2010. So what I'll do now is basically have a few comments which I've seen on the Bangladesh Competition Act, in addition to what Mohammad Chaudhry Sahab has already done. And then talk a little bit about the competition law regime in Pakistan. And then few cases very briefly about in telecom sector. And also a couple of things on the e-commerce. Fahim Bhai has rightly pointed out, this is a very new area and all of us are actually in the process of learning it. And we do have a few cases in Pakistan, so I'll briefly also touch upon that one. So on the Bangladesh Competition Act, I've gone through the English version. So apology if there is anything which I've misunderstood or I've missed it. What I've seen is the first and the foremost thing which Mohammad Chaudhry has also pointed out. That is the appeal to the government. For me, this is a little bit strange because we had a case specific in Pakistan where the government was involved in a decision which was overturned by the Competition Commission. And if the appeal was to the government, then obviously it would have been a very difficult position. So for me, appeal to the government basically means that this is a compromise on the independence of Bangladesh Competition Commission. So I'll talk about that case when I will be talking about the Pakistani competition law. Second, I have not seen any provision which talks about the power of Bangladesh Competition Commission about granting exemptions, which is quite a normal power, whether it's individual exemption or block exemption. This is there in most of the competition law, and I've seen also that the competition laws in the region, including Pakistan, those powers are there. And I think in some cases it is necessary when you really want a new area to be developed. I also didn't see any power regarding approval of mergers. Again, I'm sorry if I've missed the translation in the translation. And then the most important power which is required for the competition authorities where there is a complaint, because we don't expect only you do have the power of forcible entry, entering the premises, searching, and then seizure of normally computers, records, and everything. So I didn't see that power also, and I think if it's not there, then it's extremely powerful and extremely useful, because other than if you don't have it, then you would rely on the evidence which is provided by either by the complainant or by the accused company or entity, which is going to be extremely difficult, because either the complainant might not have access to it and the other side may not be willing to share it. So unless you have that power to forcibly enter the premises and search and seizure, the role of Competition Commission is going to be limited. I think there is a question about this also. So that's why I thought that I'll just briefly mention that. Another concern I have is this section 24, which actually make it a criminal offense if you do not honor any particular order of Competition Commission. That I think is unnecessary, because the Competition Commission has the authority and the power to make or to impose penalties. By introducing a criminal offense, I think it's going to scare investors and business people, especially when you have to prosecute them in the sessions court. So I think this is something which I'm not sure, but I'm sure the business should have some concerns about it. And I also didn't see the relationship between the regulatory bodies and Bangladesh Competition Commission, because I'm sure Bangladesh Competition Law came in 2012. There were regulatory bodies before that. They had certain provisions about regulating competition in their particular sector, which mostly are sector-specific issues. So I didn't see that, but I'm sure Bangladesh Competition Commission would have some sort of MOUs or cooperation agreements with those regulatory bodies and decide which issue they will take care of and which Bangladesh Competition Commission will do that. And I also share experience from Pakistan, because this was a contentious issue in the beginning. So coming to Pakistani law, which is in line with the best practices all over the world, since World Bank was involved, so we actually learned a lot from the other jurisdictions to see that we do not miss out any of those powers, because unless you make the Competition Commission powerful, you would not be able to get the effective results. So in addition to the usual competition things, two more powers were given to the Competition Commission in Pakistan. One was to look at the deceptive marketing, and the second was fair trading. These are very, very important in terms, it was considered very, very important because one, that those two areas were not addressed in any other law. And the second was that when you're talking about consumer protection, it is extremely important that you have somebody to look at the deceptive marketing practices in the, which may not be anti-competitive, but which definitely are going to hurt customers. And then of course, fair trading principles. So on the relationship with the other regulatory bodies, there was an initial challenge from the regulatory body, because they were saying that we have the powers to regulate competition in our law, and we also have certain license obligations in the licenses which have been issued. So why we should give this power to Competition Commission? And then there was a usual legal argument that which law is general law and which law is special law and which law will take precedence over the other. So after a debate and then a lot of arguments on both sides, there was an agreement that we need a cooperation agreements or MOUs between different regulatory bodies and the Competition Commission. And one of the arrangement was that in some cases, the regulatory body will look at the ex ante competition issues, and the competition authority or Competition Commission will look at the ex post competition issues. And that's how things are working. And then the regulatory body are also helping out whenever there is a competition issue or a matter. On the independence, I've already mentioned that this appeal to the government in Bangladesh. So what in Pakistan was done to ensure the independence of Competition Commission, as was done in India, was that there would be an appellate tribunal, especially for the cases. One, that it would have a speedy disposal, and the other is that it would be an independent body which would be hearing the appeals against the decision of the Competition Commission. And after the appellate tribunal, the matter will go to the Supreme Court. So that's a fast track process which has been developed. On the couple of telecom cases, very quickly, as I mentioned, the role of government. Pakistan had a case a few years ago where an international clearing house was established by the international incoming traffic licensees who are bringing in traffic into Pakistan, and like VoIP licenses in Bangladesh. So they were bringing in traffic, and because of the competition, there were about 14 licensees, and because of the stiff competition, the prices were going down, and it was getting very close to the domestic termination rate. So they all sat together and then decided that if we continue competing against each other on price, we would not be able to make money. So let's create a cartel. I mean, that was very interesting that they decided that we need to create a cartel where one operator, which was the PTCL, government-owned operator, like BTCL, will lead this effort. They will be the only one who would be negotiating termination rate internationally, bringing in the traffic and distributing fixed share to the rest of the 13 licensees. So that was a perfect cartel, totally against the competition law. But somehow they convinced the government to approve it. They convinced the Federal Board of Revenue because there were taxation issues involved. They also approved it. And then the regulatory authority, Pakistan Telecommunication Authority, which was the regulator of the telecom sector, they also approved it. So with the approval, they started and running it. And it was only the Competition Commission which came up and said that this is a big cartel. We cannot allow this. And thanks to the Competition Commission, this cartel was broken. It was dismantled. And the competition was used again into the international incoming. So this was a typical case, and I think that also exposes the fact that there is a possibility that the government might be involved in certain decisions which may be against the competition law. And in various sectors, we have seen that the government actually, in some cases, fix the tariff, make sure that you don't have competition. This would see in different sectors, in the agriculture sector, yeah, then you have cement, and then you have even the power sector. Second case was regarding the right-of-way, where one of the housing authority, they decided that we will give access to only right-of-way to only one or two operators. And because of that, everybody else was excluded. Our result was expensive service, more money for that housing authority. This was also taken up by the Competition Commission. It was this agreement was declared illegal. Then one very important merger case came up before the Competition Commission in the telecom sector. It was between Jazz and Warid. Jazz was the Mobilink, like Banglalink in Bangladesh, and then Warid is Warid. And there was a very thorough investigation to see that what would be the impact of this merger on the telecom market. All the other operators were invited. There was in-depth analysis on the revenues, on the customer base, and also what kind of assets like spectrum share, what kind of advantage this merged entity will have. And after a thorough investigation, even PTA was, the regulatory authority was also involved in this. And then it was decided that it is not going to have a significant impact on the market, and the merger was allowed. Last was that there were certain deceptive marketing practices by some of the telecom operators. So there was also show cause notices issued, and then action was taken. And then those operators were asked to provide the evidence, and in some cases, their offices were also raided. Now coming to the e-commerce area, this is, as Fahim Bhai said, this is a new area. This obviously has its own challenges, and then we are all looking at this particular area and see that how we can apply the competition principles in those areas. And I do think that we really don't need to have any particular amendment in the existing law in Pakistan, and the current legislation actually covers the situation which we are seeing. There were two particular cases. One was there were a lot of complaints about an online shopping website. It was kemu.pk, and the Competition Commission actually issued show cause. Then there was a thorough investigation. They actually looked at their practices about the relationship of buyer and sellers, what is the return policy, the payments and shipping methods, and especially the vague terms and conditions. That was extremely carefully were looked into. And then also see that how the customers are being deceived. So this was a landmark case where the e-commerce platform was investigated. And then the other was when this Alibaba came to Pakistan. They acquired Daraz in Pakistan, and also 45% share in one of the microfinance banks. So again, a thorough investigation was done before the approval. They actually gone to large extent, see that what would be the impact on the e-commerce side, on the RAS side, and then also on the digital wallet, because Easy Paisa was owned by that particular bank. So after again a thorough investigation and then hearing from all these stakeholders, it was decided that it's not going to have any significant impact on the market, either in the wallet or in the e-commerce side, and that's how it was approved. Now, these were the two cases, and then there were also a realization that while going through those cases and then hearing a lot of complaints like Fahim Bhai was mentioning, the Competition Commission is actually working right now with the industry to come up with the e-commerce policy guidelines. So that framework will come out, which will actually give guidance to the e-commerce platforms that how competition law is going to be applied on them and what they are supposed to do and what they are not supposed to do. So these guidelines are still on the being drafted, but the focused area are to build consumer confidence into the electronic marketplace. That's extremely important. Second is to encourage fair trade practices in the cyberspace. And third was to prevent any possible abuse of power, either by a big player or anti-competitive behavior, and also address if there is any deceptive marketing practices. So these are the main areas on which this draft e-commerce policy guidelines is being worked on. And hopefully very soon we will see a draft, and then I will be happy to share it with everyone here. So that's very briefly my views. Happy to answer any questions.
So thank you so very much for the invaluable sharings of your experience and thoughts. I think if I may recap, you've talked about two cases where cartelization has been done in Pakistan, which was approved. One of them was approved, other was not. And then you also, from your sharing, what we understand that merger control is something that we really need to look into in terms of Bangladesh. And we do not have, you have rightly pointed out that the merger control you've been seen in the Act of Bangladesh. So that actually has been left out from the Act. So currently, maybe the Commission is working on adopting a merger control regulation. So we'll see the developments, how it comes along. So thank you very much. We'll now move on to Professor Dr. Enamul Haq, sir. Because it's very inevitable that the relationship between competition law and economics and the rule of reason, the jurisprudence, actually, a lot of it comes from the economic theories, supply and demands, and all those principles. So we look forward to hear from Dr. Enamul Haq, sir, to share his expertise and his thoughts in this aspect of competition law. Sir, over to you.
Thank you. Can you hear me?
I can hear you, sir.
Thank you. Thank you very much, Ms. Ba. After a long time, I see you now. And Manoj Chaudhary was also here. So thank you very much. Remembering me, yes, we worked long time. We have been working on the competition issue before it has become a law. And that is, and one of the reasons we were pushing for competition issue, because competition market imperfection is not something that is new. It has been here at the moment market has started. If you think about the Sherman Act, it was 1821, if I remember, something somewhere there. This was the law was passed. Monopoly Restraint Act was passed by the British. So you can realize that the market imperfection was the question that always happens. The market has, initially the market was not competitive market. If you go to the primitive market structure, it was competitive. And then obviously market imperfection came. And one of the objectives of competition law, as I see, is not what many, you have mentioned also the regulation. I think it's more than regulation. The primary objective of competition law is improving economic efficiency. The second most objective of the competition law is to ensure that there is innovation and there are new enterprises who enter. These often the enterprises, smaller enterprises are in trouble because the larger players like Amazon, Ashur has talked about, big player can play the game differently and the small players do not know where to go because somebody can reduce the price, and if somebody reduce the price, consumers will be very happy. Although in Bangladesh, consumers are very unhappy when price goes up, but somebody can deliberately reduce the price and kill the competitors. And that is not something that is expected out of company. It is also not competitive because end of the day, the market price will go up. So the idea of competition law that we think about is to ensure that innovation and efficiency enters. Although I can see most of our discussion that we think is regulating the players, and I think the principle should little bit change. And in this particular case, the question of evidence comes. And evidence is something very difficult. If you go to the law of evidence, evidence could be done in many different ways. Imagine a criminal court and there is an evidence. And evidence comes from experts, like forensic expert. No, he was not the witness, but he provides that evidence that this act was done by something. This is not a suicide or this is a homicide. Things like that is expert evidence. So here we actually do in economics a lot of study around the world that economics, they say forensic economics. We have in my university competition law, economics of competition law. We teach it to our students, and the reason we have done it the first time in last year during COVID, and the reason we do it because I think the principle behind this is not regulation. The principle is competition efficiency. So how do I know a market is competitive just because non-competitive? Is it because of price going up? I have just given an example. Price going down could also lead to non-competitive behavior. So that is what we should think about. When it comes to the regulating, if you say, what do I regulate in terms of competition? I think we regulate, we want to see three things. Number one, that whether new entry is prohibited or restricted. In a market when new entry is prohibited or restricted, a lot of time it is restricted because of the government regulation. So I believe that there was pointed out by, I think, last year from Pakistan, and he mentioned about it. The government, the regulatory agency may also restrict competition. And so competition law, competition commission must have rights on them and say, look, you cannot do certain things that would restrict competition. Price fixing. A lot of time price fixing is also done by regulators, not price making prices, but I'm talking about fixing the price, not to go above certain things or below something. So there are issues of competition commission that come into the jurisdiction of government regulatory agencies, and these are issues. Second important issue is to ensure that why market has non-competitive behavior. One of the reasons is obviously to raise profit, to get the control of the market share. That does not mean, and this is important for us to understand, that if the market is not competitive, we have to bring them to competition. What I see in economics, they're bringing full, perfectly competitive market may become too costly. That's why even in oligopoly, there are competitive solutions. Nash equilibrium in economics, we say, is a competitive solution. So yes, even in an oligopoly market, which is not perfectly competitive, there are competitive solutions. So when we want to say the market is non-competitive, we often look into the sense like what we say normally, what are the evidence? It's evidence like the tangible evidence. What I'm trying to say is that there are theoretical evidence possible, and those evidence using economic principles could be shown, just like forensic scientists show that this is not a homicide, this is a suicide. Similar thing, or this is not a suicide, this is a homicide. The question like that comes from expert witnesses and from a theory. Similar theories must be used in order. The third issue that we often talk about competition is often non-competitive behavior is linked to corruption. Agreements, vertical agreements, you'll find out bid rigging is a good example. these are all part of the corruption activities. Sometimes these are happening because there is a corruption issue between the government offices and also the leaders. And those are issues where Competition Commission may look into. So if I look into Bangladesh Competition Commission, I think the competition law should be thought carefully, because most of the time we say competition, whenever price goes up, we say, where are the competition commission? Answer is much more bigger and broader than price. There are different ways competition can be restricted, and restricted competition we can change by using those principles. If you think about merger and acquisition, it's another example. All merger and acquisition does not necessarily mean non-competitive, anti-competitive. There are merger and acquisition that bring efficiency. Similarly, another issue I think Manoj Chaudhary mentioned about the relevant market. Defining relevant market is so difficult. Every competition commission around the world has been trying to find out what is the relevant market. And these are all coming from certain principles, and there are certain parameters that we can estimate and say this is what is the relevant market. I'm giving you one example, probably an example of trying to understand that if I want to look at the impact of an anti-competitive behavior, does it mean reducing price or increasing price? Sometimes, as I mentioned, that increasing is a dynamics of market. Today I can reduce the price, tomorrow I will increase. So the commission must be careful in defining that, okay, how do I define this kind of competition behavior? Similarly, if I look into the impact in terms of entry, a lot of time, even in Bangladesh, large producers would not like small producers. Many markets have been dominated within Bangladesh, large producers. I'll give you one example which is related to e-commerce. Search engine. Is search engine fair? So if I'm selling a product, let's say I'm selling a product on Garage, or I'm selling a product on a market where individual sellers are selling, there are issues in the world to say, okay, if the seller has created a search engine in such a way that only someone's product is coming up, popping up. So pop-up is defining certain producer and not me. In that case, in the search engine, the ordering has been started. That certain particular producer's product comes up all the time, and many other small competitors' products never comes up. So if you are searching for products, these are issues. So if you look into Competition Commission, I think it's more, they should think about not based on always on the price rise, the way people think about it, not based always on cartel, but more of a market efficiency. That how you are looking at the market, and how do I protect newcomer, new entrepreneurs, small entrepreneurs. The reason we have competition is to protect new entrepreneurs, because these are small entrepreneurs, they cannot go anywhere because somebody can reduce the price and everyone will say, fantastic, price has gone down. But it may be as a strategy to kill the smaller producers. So Competition Commission is actually a refuge for small entrepreneurs, and that is a role Competition Commission should play carefully. And it is true for both coming up and try to make sure that we understand that the rise of competition law is linked to globalization. So when the global players wanted to enter into markets around the world, they realized that many markets are very protective and many markets are very nationalistic. So we need an independent commission through which we will be able to enter. At the same time, there are also local entrepreneurs who will say bigger producer, because of the higher market scale of economies of scale, they can sell at a much lower price and I cannot compete. Not necessarily dumping. Dumping is an example of when somebody is selling at a below marginal cost price. But I may not be selling below marginal cost price. I am a large producer and I'm selling at a price which is not technically dumping. However, it's going to kill every other market. So Competition Commission must use the principle of economics and say, okay, how do I define this? The way that discussion we have seen, and I've seen many other times when people say Competition Commission must do this, is only when price goes up. But answer is, what is your objective is not to regulate the prices. Your objective is to ensure that enough producer enter into the market increases. If the market does not increase, the biggest problem will be the economy of the country. You have seen Bangladesh government have been asking that, and we are educating people, and none of them are becoming entrepreneurs. Now, answer is entrepreneurs cannot start operation if there is no free level playing field for producers. So the producers must have the level playing field for entry into the market. And Competition Commission must think carefully that how do I regulate the market in order to ensure this. So my primary point that I'm trying to push in is to look carefully between the lines that what is the real objective of the commission. The real objective of the commission is to promote entrepreneurship. And there are many different ways. I'm giving this point that we have talked about it. There are relevant market. There are many cases. I was just going through the document. There are many cases where relevant market has been very difficult. Whether the mango market is relevant market for lychee market. It's a very difficult question. But one can kill the other market depending on how the situation is played. So I'm giving you the idea of a relevant market. It's not the same product, it's similar other product. Whether spare parts market is relevant for the car market, one per market can kill the other one. So I'm giving you that I think Competition Commission, we should look for strategies that will create innovation. I always push for this. Whenever the law was drafted, I actually asked, if you remember, sir, that I also asked the question that, look, we should ask, we should remove the word control and regulation. We should push the word innovation and efficiency. That is the primary objective of promoting competition in the market. And that may be prohibited because of article agreements, trade treating, that may be prohibited because of a cartel, that may be prohibited because of merger. But just saying that all mergers are bad, I would not agree. And these are all based on economic principles. So I think we should be careful between the line, not to label certain things in such a way. Not all price going up is anti-competitive, not all price going down. Sometimes price goes up because otherwise market will become non-competitive. Why? Because if the price goes up and you do not allow the prices to go up, producer will collapse. In other words, you'll find out many producers will lose the market and they will leave the market. And if they leave the market, somebody who can tolerate long-scale profit, they will only survive. So eventually you create a monopoly by not even allowing prices to go up. So I'm giving you the dilemma that Commission will have because the symptoms are not clear all the time. And I think we should be careful on that. The other issue that I think I will not be very long. The other issue is that the investigation. That's a very important one. When you are investigating, and I think, and there either you can have a suo moto. I don't think in Bangladesh competition law there is a suo moto investigation rule. I don't know whether it exists. If it does, it's one way to do it. Another way to raise complaint. And the biggest point is that most producers, smaller producers in particular, do not know how to raise complaint. So if I remember, the Competition Commission did solve certain problems from anti-competitive aspect in Bangladesh, 4 or 5 of them, maybe, if I remember them. And the reason they have solved it is, the way they have solved it is more of a mutual agreement. In other words, more of a persuasion, and not a bad idea if you are doing more of a persuasion at the beginning. But you need to raise awareness among the people that, look, this is where I can go to raise that somebody is killing. And that is something for people to think about, because often that many people do not know where to go if I'm pushed by someone else. So I think I will stop here, because these are the issues that I thought I should raise as an economist, and I think economic principles should be understood. Thank you. Thank you very much.
Can I just?
So thank you. So if I may sum up, so you've talked about innovation, the importance of innovation and efficiency. And also from your words, I think we can get some guiding principles for the Bangladesh Competition Commission, which will help us in developing a strengthening regime in Bangladesh. You also have talked about the evidence, how the economic principles and the evidence will work in this sector. So, sir, with follow-up questions, we might come back to you, but thank you very much for sharing your thoughts. Now, I'd like to move to our next speaker. She's a lawyer by profession, Barrister Nihat Kabir. Barrister Nihat Kabir is the current president of Metropolitan Chamber of Commerce and Industry, MCCI, in Bangladesh. She's also the senior partner of Syed Istiaq Ahmed and Associates, one of the oldest and largest law firm in Bangladesh. Barrister Nihat Kabir, she has obtained her bachelor's degree and also LLM degree from University of Cambridge, United Kingdom. She has joined the Bar of England and Wales in 1988, and she's been working as a director in various institutions. Most notably, she worked as a counsel in the Office of the General Counsel of the Asian Development Bank headquarters in Manila from July 1996 to February 2000. She's also the chairperson of the executive committee of Ain o Shalish Kendra in Bangladesh. We'd like to invite Barrister Nihat Kabir. We have 3 specific questions. May we have Madam Nihat Kabir, Appa apni, can you hear us? Hello?
I can hear you loud and clear. Can you hear me?
Yeah. Okay, I can hear you, but very, it's not very loud, but I hope the rest of the audience can hear me. So one of the first question I would come to you, it is a fundamental concern for foreign direct investors, lack of enforcement mechanism. We at times raise concern that the enforcement mechanism of law is very weak in Bangladesh. And we also suffered from, at times we suffered from lack of legal framework in many areas. However, the competition law regime in Bangladesh is at a very nascent stage. So do you think it is likely to impede Bangladesh's ability to attract foreign investment?
Thank you very much. Can you hear me a bit better now?
I can, Appa, I can.
Good.
Thank you.
And a very good evening to everyone, particularly our esteemed chief guest, with whom I've had the opportunity to work for many years now. Unfortunately, not so much now that Mufizwa, you're in the Competition Commission, because not too many cases have come up. I will go into answering this question, but if I may have 2 or 3 minutes before that to give a little bit of background. In some ways, it's quite funny. I'm here wearing my second hat, I think, as chair of the Metropolitan Chamber. But when I was asked to join this webinar, I looked through my files and I saw that I had actually prepared the first draft of the Competition Commission Act in 2008 as part of a World Bank project. And so I look back at all my notes and all that, and I must thank Dr. Namul Haq. I trust I've got the name right. Yes, Dr. Namul Haq, for saying what was the basic concern at that time, both from the business community and from us as lawyers, which is that we look at competition only from the point of view of price increases. We don't look at it from an overall point of view of consumer welfare. We ignore a lot of factors which can result in a change of price, which Dr. Namul Haq has very, very nicely pointed out. And politically, over the decades, not just years, over the decades, we have been seduced by having an easy group to blame, the so-called nebulous syndicates. So now that we have a law, we have a commission. We've had the law since 2012. We've had the commission since 2012. And in fact, prior to the current chairman coming in, we didn't hear very much about the commission at all. Now, at the time of drafting the laws, we looked at very many laws across the world. And at that time, we had summarized there were approximately 116 countries and jurisdictions with competition laws. And they had very different approaches across the board to what competition law at that time, 2012, 2008, when I was looking at this, was trying to address. By previous speakers, Mr. Manish Chaudhry, Mr. Samha, they've very nicely sort of pointed out the various aspects of this law, and they're all extremely valid. A lot of them are much more valid now, perhaps at that time. And another thing, what happens in a country like Bangladesh, we end up putting these laws in places not because we feel an organic need for it, not necessarily because we think that it needs to be done, but because there is a conditionality in some funding or something from the IMF or the World Bank or the ADB, and that really does not work to give us what we actually need. But anyway, there was a lot of discussion and we prepared a draft, but I must say that when the law was finally passed in 2012, our policymakers chose to go along the lines of the laws that we have, for example, for the Securities and Exchange Commission, Anti-Corruption Commission, etc. And we end up with what Mr. Chaudhry pointed out. We have a provision for appeal to the government. In our original draft, the provision was for appeal to the court. That's just one example that I'm giving you. It has also now been 9 years since the law, well, yeah, close to 9 years since the law has been in force. And we still don't have the relevant rules or regulations. I will give you one example, again, taken from what one of the previous speakers spoke about, which is, I think, let me just look at it, section 24. This will address 2 points. So section 24 talks about combinations, the regulation of combinations. And combinations, there was a question that whether the approval of mergers was included there's section 21, whether the approval of mergers was included in the law. It actually is here in a slightly roundabout way. It says that any combination which may have a negative effect on competition will be prohibited, but subject, there's a proviso that if an application is made which shows that such a combination will not have a negative effect, it can be approved by the Commission. And a combination includes mergers, acquisition, etc. by definition. However, it says that the Commission needs to have regulations in place which will say what kind of combinations will require the prior approval of the Commission. Those regulations are not there. It's a little bit sad that in 9 years, we have not been able to put in place regulations. There was a lot of opposition to this law in the beginning, specifically for this reason, that in the absence of regulations, in the absence of expertise in our Commission, in the absence of readily available data, there may be scope for using this law to actually promote anti-competitive behavior. That competitors would come up with frivolous applications. And there is provision in the law to allow the Commission to ask a business to actually cease carrying out its business, even before carrying out an investigation, if the Commission feels, has reason to believe, that the activities of that business are anti-competitive. And I think that is a very dangerous trend. Then there's this whole criminalization, which I think Mr. Samhat pointed out. This is again another trend. Recently, there was a move to put in a similar provision in the Companies Act, criminalizing persons for not keeping certain records. Anyway, that was not carried through, which is a good thing. But this kind of trend of thinking in the mind of policymakers is sometimes worrying. Going to a specific question, Mr. Misbah, we saw, you've just heard, Mr. Fahim Masroor was saying that price dumping, I suppose predatory pricing, is something that foreign investors come and do, multinationals come and do in Bangladesh. Now that's a very wide, that's a very sort of broad allegation, if I may say so. If, for example, if I think that the regulators are going to take that approach to foreign direct investment coming in, that, oh my goodness, they're coming in and they're going to cut down the prices and they're going to then, absolutely disrupt the business, and domestic business is not going to be able to compete, so we're going to stop them, then that is going to be very, very problematic for us. In Bangladesh, we have been desperately trying to attract foreign investment over the last several decades. And once we have foreign investment in any form coming into Bangladesh, if we then subject them to this sort of a policy mindset, we are not going to be really moving very far forward in attracting them. And at the same time, we know that we are moving up from an LDC to a developing country. We definitely need to attract investment to create jobs in the country. We need to bring up domestic investment. Domestic investment needs technology transfer. It needs to be able to interact and become a part of the global supply chain if it is to grow fast enough to create the sort of economy we need to accommodate our growing young population. And therefore, we really need to look at we need to go back and look at how the world is looking at competition law now. And we need to make sure that when we do attract foreign investment, even if they're bringing the price down, they're not doing it in a manner, if they're not doing it in a manner to reduce ultimately the consumer's choice, then we should leave them alone. But I would, with the esteemed chairman here, I would definitely say that a proper framework, a proper thought process into how we are going to approach applying the Competition Act needs to be put in place now, before we suddenly have a lot of complaints coming up. I don't think currently, the chairman will be able to say much better, I don't think we still have, we have the capacity at the moment to really deal with a lot of these complex issues. And a lot of the complaints that we hear about are not actually matters for the Competition Commission, they're matters for the consumer protection authorities. So the demarcation of the activities between these two authorities also needs to be made quite clear. I hope I've answered your question from the business's point of view.
You very much covered that, madam. Thank you. Now, I note that you've started the background from the Draft Act, and we can relate it very well. Me, along with even Dr. Professor Enamul Haq sir, it's a huge shift from the Draft Act to the Act that we've adopted now. On that note, what we understand that there might be a need for amendment in the Act. Also, it is very inevitable and agreed that we need some regulations, at least the merger control regulations and some other forms of regulations, which very aptly the Commission is currently working on, I believe. So do you think, in our view, the business association and trade bodies play a very persuasive role in Bangladesh in advocating such policies? Because without the business associations pushing them through and driving them, because our government has a lot of priorities, and these kind of laws, at times they do not form our priority, and that they lag behind. So do you think, what kind of interest, you being the president of MCCI, the private sector and you yourself as a president from MCCI would take in terms of advocating these policies and push them through so that we can see these regulations are into play within a short period of time?
That's a very good question, Mr. Mizu. I know, domestic industry looks upon the competition law slightly warily. As I have said, they're not sure how it is going to be applied. And there needs to be clarity on that. We do have very large groups, but then those groups should not be penalized for their success. Now, as a commercial lawyer, though, I have been recently receiving a lot of queries on what effect these competition laws may have on companies which wish to make, or investors who wish to make larger investments. They're not sure of whether, what action on their part may trigger some action from the Competition Commission. And in the field of business, it really doesn't matter whether something is positive or negative. You need to know. It has to be clear that yes, if you do X, Y, Z, the Competition Commission is going to intervene. If you do X, Y, Z, the Competition Commission is not going to intervene. Today, and I draw the esteemed chairman's attention to this, today, investors have no clarity on this. And that really creates a problem because we tell them, no, nothing's going to happen. But then they say, no, but the law is there. Tomorrow somebody might, maybe the chairman, one of the members might think that no, something needs to be done. One of the competitors may come and, push the Competition Commission to do something. So they're worried. And I know for a fact that several large investors have been hesitant to make further investments in business in Bangladesh, both domestic and foreign, because of this uncertainty. Therefore, it is very much necessary, if the law is going to be there and if it is going to be enforced, it is very much necessary to have clarity on the framework within which it is going to be enforced, and the rules and regulations, the processes need to be put in place so that there is no apparent arbitrariness or discretion in the application of the law.
Thank you, Madam, for that. On the very relevant point that you've mentioned about the mindset, I guess, if I may translate it in my way, of the local firms. So compliance is an issue, and I think it is our duty that we at least do our bit from the private sector to make them feel the need of compliance, make them more compliant towards the law. So what role do you think we as a private sector can take in ensuring that the local or domestic firms, they develop a mindset for compliance of competition law, and that actually could perhaps lead us towards, to a great extent, to develop a strengthened competition law regime, as well as with the strengthening the commission itself too. So if you could very briefly answer that.
Investors are going to comply with law if it is clear how the compliance is going to be measured, what they need to comply with, if it's transparent, if the authorities who are ensuring compliance are accountable and transparent, and if there's a level playing field, and if the cost of compliance is reasonable. Just having a law there, also, this law, there haven't been that many cases. There's not much of a framework. So when you say comply with the competition law, there's not a lot that I can do off my own to go and say, okay, here I'm compliant. If a question arises about any of my activities, I will respond to whatever investigation or inquiry the commission has. But there has to be transparency, accountability, and uniformity of application to all stakeholders. And the cost of compliance cannot be exorbitant. If these parameters are met, then I can tell you that businesses will be inclined to comply rather than not. But just finally, the one thing that had started off with, and again, going back to what Dr. Namul Haq said, you know, in Bangladesh, like in many other countries, and I think Ms. Assam had also mentioned the case, the competition is not necessarily between 2 or 3 or 10 players in the same sector. It is the consumer versus the producer or the seller of the services or the goods. I know, you know, for example, in Bangladesh, if Pepsi is going to raise the price of a bottle of Pepsi by 5 taka, they'll call up Coca-Cola and say, guys, we're raising it by 5. And Coca-Cola will promptly say that I'm also raising it by 5. Same thing happens in cement. Same thing happens in steel. You know, they maintain this balance among themselves. So that is where the tension needs to be, to ensure that the consumer's choice is not limited. Thank you.
Thank you, madam. You're leaving us very at a very nice junction where I think the cost of compliance, the need for level playing field, transparency, accountability, and uniformity comes in. And with them, I think it's very important and relevant that we take forward and consider competition law advocacy programs within Bangladesh. And the Act itself has a very specific section on carrying out competition law advocacy to make the businesses, to make the stakeholders educated on how this law is applied and how it could have an impact on us. So on that note, I would like to invite our next speaker, Mr. Evan Williams. So if I may give a brief introduction of Mr. Evan Williams. Mr. Evan Williams is serving as a long-term detail and as the United States Department of Justice International Computer Hacking and Intellectual Property Coordinator for Asia. Just to let you know that Evan has been in Hong Kong, US Embassy for the last 5 years. He just recently has been done with his term in Hong Kong, and he went back on last weekend in US. So we kind of brought him from his comfort zone to come and speak. So he is now based in US. And he's been actually coordinating and delivering intellectual property rights and cybercrime prosecutional services and judicial trainings and technical assistance throughout Asia in different countries. He's been in the ICAP position. He served as a senior counsel with the Department of Justice, Computer Crime and Intellectual Property section, where he specialized in the criminal prosecution of intellectual property and cybercrime offenses. Before joining CCIPS, Evan Williams served as an assistant United States attorney in the United States Attorney's Office for the Eastern District of New York, and before joining the Justice Department as an assistant district attorney in the New York Country District Attorney's Office, where in both offices he prosecuted a wide variety of violent and white-collar crimes. Evan Williams is a graduate of Columbia Law School and also Harvard College. We'd like to invite Evan Williams. And Evan, you can hear us?
Yes, I can. Can you hear me okay?
Okay. I can. Good to see you, Evan. And thank you very much to agree to be here with us.
Well, thank you. Thank you so much, Mr. Mishma, for inviting me to be a part of this extremely esteemed panel. It's been a very interesting discussion so far. And as a caveat, I want to let everybody know that I probably know less about competition law than anybody else here, in particular, the Honorable Chairman. But I'm flattered to be invited to be a part of the discussion. Perhaps let me start on a very small, I'm sorry? Let me start on a very small scale. As Mr. Mishma knows, I am deeply connected to Bangladesh because I had the privilege during the 5 years I was in Asia to meet, fall in love with, and marry a Bangladeshi woman who at the time National Board of Revenue. I'm now back in the U.S. With my wife, Novira Mosam Chaudhary, and just a couple of days ago, she, on a tip from the Bangladesh High Commission here in Washington, D.C., visited a couple of Bangladesh groceries. And I think they represented the essence of competition as we like to see it here in the U.S. They were both in the same strip mall in Arlington in Northern Virginia, where there were at least 4 other Bangladeshi businesses. And so my wife, being the thorough consumer that she is, decided that she had to visit both of the major Bangladeshi groceries, which were located about 4 storefronts from each other, offering virtually the same stock. They both had mangoes, which my wife and son and most Bangladeshis love. And so my wife decided that she wanted to get some mangoes. From what I could tell, the mangoes looked exactly the same, seemed to come from the same source, but she didn't think so. And so, you know, in the true spirit of competition, she bought a crate of mangoes from both shops, so that we now have 2 crates of mangoes. Both shops benefited from my wife as a consumer. Even though, you know, they were just 4 storefronts apart. So that's the kind of healthy competitive environment that I think we hope to see by having competition laws. As I think you all know, in the US, we call them antitrust laws. And I think that's basically just a product of the fact that our laws have been around longer than most of the other countries in the world. So that's why we still use this outdated term. Basically, so far as I've been able to find out, going back to the fact that it was, I guess, corporate trusts back in the 19th century, which these laws were originally designed to break up. Also, you know, in the US, making a little different, I think, than smaller countries like Bangladesh, it is enforced through a competition of federal and state laws, although in the US, I think the majority of the enforcement efforts are done at the federal level. At its root, our laws are designed to promote competition and to prevent monopolies, which I think are the same main aims that competition laws all over the world are designed to remedy. But you know, the way that those are enforced and the political climate has a huge effect on that. You know, in the US, as I think most of you know, our laws are at the federal level, basically 3, the Sherman Act, which is primarily designed to prohibit price fixing and cartels, the Clayton Antitrust Act, which focuses on mergers and acquisitions, and then the FTC Act, which primarily created the Federal Trade Commission, the main civil body, administrative body in the US, which is responsible for antitrust enforcement. You know, we accomplish things, I think, somewhat uniquely by a combination of civil enforcement and rather robust criminal enforcement. And, you know, as a federal criminal prosecutor, that's the perspective with which I'm most familiar. And, you know, let me be clear, I'm not with the antitrust division. I'm not an antitrust expert, and I'm certainly not speaking for the Department of Justice here. But I am a criminal prosecutor. And so I see the role for the criminal authorities. What strikes me as a little bit different between the US approach and what I see in the competition law is that here, the only criminal sanction seems to stem from a direct violation of the commission's orders, whereas in the US, the actual substantive acts are criminal. So we can bring criminal prosecutions not just for violating an order, for instance, of the Federal Trade Commission, but we can prosecute somebody for the price fixing itself. You know, that said, criminal actions are fairly rare in the US, and they tend to focus on those activities which are, you know, unquestionably violations of competition law or antitrust law, things like price fixing, which, you know, we consider per se illegal in the US. in preparation for this discussion, what struck me looking at the history of the U.S. Competition efforts, antitrust efforts, and as I said, I think the main thing that we have to offer in the discussion is not that we're any better or worse at it, but just we've been doing this for longer, all the way back to the turn of the 20th century, is that our efforts seem to have been driven in some ways more by the political climate of the time than by the actual laws on the books. So, when we first started using these laws at the turn of the 20th century, we basically applied the rule of reason, and the courts seemed fairly loath to aggressively enforce these laws to give victories to the government. The Standard Oil case in, I think, 1911 being a notable exception. But then with the presidency of Franklin Roosevelt and the coming of World War II, the United States started to take a much more structuralist approach, where we were aggressively trying to promote competition in all fields, and the government had a larger role in sort of dictating how this should work. And then in the 1970s, you had an influential set of economists and law professors affiliated primarily, I think, with the University of Chicago, who kind of made the pendulum swing back the other way. And the federal government, I think in the early 70s, lost its first ever antitrust prosecution. And since then, they've been fairly rare. It'll be interesting to see what happens with what I think is probably the biggest federal antitrust action in a couple of decades, and that is the suit against Google, which was announced just before the end of the last administration. It seemed a little out of character for that administration, which was in other ways generally pro-business, but as we all know, the past president had his struggles with Silicon Valley, so who knows? But so the timing, as I said, and I'm not speaking for DOJ, the timing was a little bit odd, but anyway, that was announced right before the end of the last administration. And we've been discussing e-commerce and some of the other modern trends. It'll be interesting to see where this goes. I think right now they're saying that the trial, if there is one, and there may well not be one, wouldn't be before 2023. But some of the theories that the government is advancing are that Google was executing exclusivity agreements which forbid the pre-installation of competing search services, that they were trying to, on the other side, trying to force pre-installation of Google search engines in prime locations on mobile devices and to make them undeletable, that they had long-term agreements, that Google had long-term agreements with Apple, requiring Google to be the de facto exclusive general search engine on the Safari browser. And then, again, I'm not an antitrust expert, but most interestingly, using monopoly profits to buy preferential treatment for its search engine, creating a continuous and self-reinforcing cycle of monopolization, which seems sort of much more vague and something which you could accuse almost any company of, using its profits to try and maximize its position in the market. At this point, I think the government is hoping that the courts treat this somewhat like the Microsoft prosecution, which was probably the last big antitrust action which the US government took against a tech giant, where we won in the trial court, were partly reversed in the Court of Appeals and ultimately settled. But the government has tried to liken Google's actions to those of Microsoft's, at least those issues on which the government won last time. So with that, sorry about that. I think I muted myself. With that, I think we're already running long, so I'll turn this back over to Mr. Mishba, but again, thank you for the opportunity to be a part of this discussion.
Thank you, Evan Williams, for sharing the interesting story of Mango that Novera did. But anyway, I would like to come back to you with the audience questions, if there is any. However, I would like to once again thank you for being here, despite having jet lags, I believe. Now, we'd like to move to the chair of the panel, Mr. MD Mofizul Islam, sir, the chairperson of Bangladesh Competition Commission. If I may give a brief introduction of our distinguished chair, Mr. MD Mofizul Islam. He joined as a chairperson of Bangladesh Competition Commission on 28th October 2019. Before he was appointed as the chairman, he served as a senior secretary to the Ministry of Commerce. He received the Best Award on National Integrity Strategy in 2017 and 18 financial year. Mr. Mofizul Islam joined Bangladesh Civil Service Administration cadre on 21st January 1984 through regular BCS exam of 1984. He did his Bachelor of Arts honors degree from the Department of Bengali with profound success and Master of Arts from the same discipline of the University of Dhaka. He is a regular trainer of Bangladesh Public Administration Training Center, Bangladesh Civil Service Administration Academy, National Academy for Planning and Development. He participated in various training programs at home and abroad. He completed the Leadership for 21st Century course from Harvard Kennedy School under the Harvard University of the United States. It is my utmost pleasure to welcome Mr. MD Mofizul Islam, the chairperson of the Bangladesh Competition Commission, who is the chair of this panel today of the webinar, to deliver his valuable speech. Over to you, sir.
Thank you very much, Mr. Moderator, for introducing me in such a good manner. At the outset, I would like to commemorate the father of the nation, Bangabandhu Sheikh Mujibur Rahman, on his 100th birth anniversary, and also all the martyr freedom fighters of Bangladesh on the golden jubilee of the independence of Bangladesh, which we are celebrating in 2021. My colleagues in the commission, esteemed panel speakers, Mr. Manoj Chaudhary, Mr. Fahim Mafroor, Mr. Aslam Hayar, Dr. Enamul Haq, Barrister Nihat Kabir, Mr. Evan William. From India, Pakistan, USA, and Bangladesh. The officials from Bangladesh IP Forum and the audience participants, a very good evening. It's a great honor for me to be the part of this webinar and having the opportunity to share our thoughts, ideas, and experiences. I would like to extend my cordial thanks to Bangladesh IP Forum for organizing this webinar, which I believe will help enhance the understanding of competition law regime in Bangladesh, and express my gratitude to all the participants for their lovely participation and valuable comments. Competition law comprises both economic and legal theories. Competition law promotes maintaining market competition by regulating anti-competitive conducts done by enterprises. Effective competition policy can play a vital role to increase GDP growth. Moreover, the benefits prevailing competition in the market are lower cost and prices of goods and services, better quality, more choices, variety, innovation, greater efficiency, productivity, greater wealth, equality, etc. Bangladesh emerging as a middle income country, and it is expected that by 2041 would be a developed country. Bangladesh needs to maintain the projected growth through increasing local and foreign investment and reducing or eliminating unfair competition from the market to achieve the social and economic goals. The competition law is relatively new in Bangladesh, and Bangladesh Competition Commission started its activities in 2016. We are facing a lot of difficulties from the very beginning. It is not very much familiar to many of our stakeholders. Moreover, general people are also ignorant about the law. Unfortunately, full-fledged commission only started its operation from 2020. Despite all limitations, the commission has been already disposed of 5 cases and passed orders under the Competition Act in different bounds of anti-competitive practices. 12 cases are under trial or investigation process. Some rules have been framed and some rules and regulations such as merger regulation and others are in formulating stage. Commission is trying to increase capacity of the officials by imparting training at national and international level. Commission is conducting studies in different sectors like rice, onion, healthcare, and leather sector to identify anti-competitive activities. We are also taking a project overall strengthening of the commission. The commission at this stage focused on its primary goal, namely creating awareness of the law through targeted outreach to business communities. Commission set aside to educate large and medium enterprises in Bangladesh about the competition law and adopt means as how they can comply with it. Eventually, to establish the competition culture in the society. BCC is also conducting seminar, symposium, workshop to develop awareness among other stakeholders. BCC participated in International Competition Network ICN 2020 virtual annual conference showcase program on the topic of challenges of the digital economy and annual conference. BCC also virtually participated in UNCTAD 8th Event Set Conference 2020, OECD, GFC, OECD KFC. Moreover, BCC remains engaged with working groups of ICN and participated various surveys, including Third Decade Survey, signing of the Memorandum of Understanding with Japan Fair Trade Commission and Korea Fair Trade Commission are in final stage. The COVID-19 has caused inconceivable crisis across the globe and has affected most of the sectors of the economy as well. In the COVID-induced new normal situation, the role of competition authorities has become even more critical as economies are trying to get back on track. BCC recognized that COVID-19 caused disorder in demand and supply chains in Bangladesh, worth mentioning critical healthcare products and other essential commodities and services. BCC analyzed the situation carefully on competition law perspective and advises the government to ensure competitive allocation of government announced stimulus packages to keep economic activities afloat during the outbreak of COVID-19. Considering pandemic situation, a study activity has been undertaken to determine the competitive environment in private healthcare services. BCC well aware of the challenges lying ahead like Internet of Things, blockchain, big data, fintech, artificial intelligence, etc. in digital economy. Because of the pandemic, online marketplace or e-commerce sector, e-learning, online education, telemedicine, and online entertainment have been a significant significant rise in demand. The rapidly changing and evolving digital landscape is posing new challenges for competition law and forces questioning the traditional parameters of competition regulation, making competition agencies develop innovative perspective on how to apply the existing instruments suitably and devise new tools where necessary. Capacity building is a must for competition authority, especially exercising efficient investigation techniques and using better economic analysis. In the arena of competition law, we identify a number of capacity building areas, including market studies, bid rigging, abuse of dominant market power, prohibition of anti-competitive agreements, formulating rules, regulations, etc. The creation of a network of the competition experts from home and abroad is a significant step in the area of competition advocacy and capacity building, as well as research and study on competition law issues will help us to perform better. The webinar will help in actualizing and forging new thoughts and techniques in executing competition law in an effective way. Today's program is just a beginning. I think it provides us a platform to interact, which will be used by both sides a lot in near future. In conclusion, I would like to thank the organizer, Bangladesh IP Forum, for inviting me to speak, and the eminent speakers for the invaluable knowledge they have shared. I want to mention that competition and IP law has a profound relation, and they are complementary in some areas. So my suggestion coming from IP Forum will be valuable for BCC as well as policymakers of the government. In my observation, I have found a number of points raised by the eminent speakers and participants on merit consideration. From BCC, we'll do the needful in the interest of ensuring competition in the relevant markets in Bangladesh and also in global markets, which affects Bangladeshi market of goods and services. Thank you all, and also the audience for their patient and enthusiastic participation. Thank you, everybody.
So thank you so very much for that speech. And we're thankful to you that you've been very patient and patiently hearing all the speakers.
If you say more things, the points raised by Mr. Manoj Chaudhary regarding appeal authority, that yes, we have keen observation on it. We are working on it. And about the points raised by Mr. Fahim Mashood, that about the offers of some digital e-commerce entrepreneurs, that one case is under trial. So I'm not going to explain explain it as it is under trial. And but it is in our notice, of course, that if we receive any allegations, maybe that any anti-competitive offenses are happening, that we should look into this. And about price dumping, yes, if we receive any allegation, maybe, of course, we'll look into that. Mr. Aslam Hayat also have raised the question of appeal authority, yes, that I said. And yes, he also raised one point that about the examination of information or any evidences. Yes, we are empowered, the commission is empowered, that we have that authority to examine the information or records, anything relevant to any offenses of Competition Act. And one point raised by one of our speakers that we deal with the national competition issues, and there are other organizations who look into the technical issues of their own areas. And I must thank again Dr. Anamul Haq, Mr. Nehat Kabir for their valuable suggestions we have noted. And of course, we together will move to make the level playing field for the all players, like investors, producers, suppliers, sellers, or consumers. So thank you.
So thank you very much for answering all these questions and concerns very patiently, and also waiting and hearing all the panel speakers. Now we've got very specific 5 or 6 questions, in fact 7 questions, but I think we are running out of time. It's been already 2 hours. We'll take 5 questions out of those 7 questions. These questions has been prepared by the respected faculties of various universities that are attending today. So I will actually ask, direct these questions to Mr. Aslam Hayat, one of them to Mr. Aslam Hayat, one of them to Mr. Manas Kumar Chaudhary, one of them to Barrister Nehat Kabir, and also one to Mr. Chairman. So first one, actually it's an Indian case. This question asked and sent by BRAC University. So if I may read it, sir. Sir, this is to Manas Kumar Chaudhary, sir. Sir, you can hear me, sir?
Yes, I can hear you.
Sir. So, sir, if I may read that, it's a 3 or 4 line question. The Competition Act 2012 of Bangladesh states that, sorry, so this is wrong question I took. So, in a comparison with the Competition Commission of India, CCI, probing in the case of JK Tyre regarding bid rigging, in Bangladesh Competition Commission, BCC, also is Bangladesh Competition, BCC also successful to fulfill the obligation of refraining enterprises from conducting anti-competition agreements such as bid rigging enshrined under the Competition Act 2012. So, sir, it's a comparison. The question is a comparison between CCI and BCC and what CCI has done in JK Tyre regarding bid rigging. So, I think this is the question, and if the commission in Bangladesh are equally able to fulfill this obligation, refraining enterprises from conducting such anti-competitive arrangement. So maybe both Mr. Chairman and Manas Kumar sir can address this question.
So may I go first, or will the Honorable Chairman would like to speak first?
Yes, Mr. Chaudhary, you can go move ahead.
Thank you very much, sir. So this is a specific case, JK Tyre. So what I can just briefly tell, whatever is available in public domain, because I am also involved in one of the parties defending this matter. So obviously subject to that caveat, what has happened was that in one of the states of India, they are repeatedly asking for supply of truck and bus tires to that state for their state undertakings, and the supply generally used to come from the private players. So what the state authority found, that the prices of almost all the tire suppliers were identical, excepting one who was trying to lower the price, and they thought that perhaps there was some kind of a rotation amongst the suppliers, that the winner would be getting the bid, and since everyone has raised their prices in such a manner that one of the competitors get that is the lowest tenderer, they call it, and it gets the tender. So in the process, what has happened was the prices were already inflated by the other players, even if the lowest tenderer was the lowest technically, but the market price according to their internal cost price mechanism, if that was the So if the cost price analysis internally was found to be not matching to the market realities, that is the demand supply situation in the market of previous years, or for that matter other states in India, they found that there was something fishy, and they started the investigation. It is still under the process of investigation. The whole concept in that matter was that there was some kind of a collusion amongst the bidders, and they tried to pitch for one of them so that in another state the others can rotate the same process, and in the process each one will be getting their share of the business. The question what you have asked, whether that kind of a situation can also prevail upon Bangladesh. So if I have read the law, of course, again, I go back to Mr. Aslam Hayat's caveat that I have read the English version. So subject to that correction, your law has actually spoken about anti-competitive practices to be deemed illegal. So cartel and bid rigging are complementary. So if cartel is considered to be deemed illegal, so is the bid rigging also. So in my view, there is no bar for the Bangladesh Competition Commission to investigate a bid rigging matter within the framework of the Bangladesh Competition Act. I think I've answered the question. I'll wait for the chairman's intervention. Thank you.
Sir, you can hear me? Hello?
Okay.
So shall I repeat the question?
Yes,
because
please.
half of the question is actually addressed to you, sir, I guess. So because this is a comparison between the CCI and BCC. So so the person who asked the question, he wants to know if Bangladesh Competition Commission can also be successful in fulfilling its obligation in refraining businesses or enterprises from conducting anti-competition agreements in terms of bid rigging under the Competition Act 2012.
Yes, thank you very much. Yes, our Competition Act allows us to look into the issue of bid rigging. Yes, we are empowered. If this kind of anti-competitive agreements happen, we may take action on it. Yes, thank you for this question.
So thank you. So my next question, I would come to Mr. Aslam Hayat, sir. Sir, if I may ask this question to you. So let me read it, sir, please. Access to the government's development fund has been restricted for the private banks in Bangladesh. The national commercial banks also operate in such activities where private banking is absent. This eventually reduces the competition between the public and private sector banks. The person asked the question, he wants to know if this is an anti-competitive behavior within the banking sector in Bangladesh.
Well, I'm not very familiar with the banking laws in Bangladesh, so I'm not really sure that if a shareholder give funding or stands as a guarantee for its own bank, that I don't think from the plain information, I don't think that would be illegal, but it all depends that what kind of impact it will have in the market. And that is for the Competition Commission to actually look at the impact and what kind of subsidy or support is going to be provided and whether this is detrimental to the rights of the private banks. So I'm not sure whether I can be able to answer this question, but I think this is something which Competition Commission is competent to look at.
So thank you very much for a very practical answer. Now, my next question would be, because this question has been asked by the Green University Bangladesh faculties. Sir, if I may just mention, the last question actually was sent from Northern University, which was sent to Aslam Hayat sir. Now, the next question is to Barrister Nihat Kabir. This was sent from Green University Bangladesh, one of the private universities. What is the role of civil society in raising consciousness about anti-competitive practices or activities along with implementation of rule of law. The reason I'm directing this question to Nihadapa is because Nihadapa is a leader in private sector. So if I may repeat, what role the civil society in Bangladesh is in raising consciousness about anti-competitive practices?
That's a very wide-ranging question. I'm not sure I can, give a very complete answer. But what I can certainly say is that civil society institutions in Bangladesh are pretty strong, very vocal, particularly the consumer protection, the various societies for consumer rights protection. I don't know if business people are considered to be part of the civil society, or we are considered to be completely uncivilized. But a lot of us actually do belong to institutions like this, and particularly MCCI. Our watchword is ethical business. So for our members, we try to advocate, and they certainly try to comply with whatever requirements there are. They also try to educate their own consumers in terms of health, in terms of quality of product, and such like. But as I said, there's a very broad question. But in Bangladesh, certainly the civil society organizations have had a role. As you know, for example, the ban on tobacco products. Not a ban, a ban on advertising of tobacco products. That has been brought about by civil society activism. That's just one example. So certainly there's a role to play, and they certainly do play it also.
Thank you, Appa, for the answer. Now, the next question, I think, is Mr. Chairman has already addressed part of it in his speech, but I'll still ask this question. It came from University of Dhaka. So it's a question along with observations. So if I may read, the Competition Act 2012 of Bangladesh states that combinations which are likely to adversely affect the market of goods and services shall be prohibited. There is no elaborate explanation as to what standards are to be used while determining the effects of a combination. Furthermore, even though the BCC was tasked with forming the rules under this act, the rules are yet to be formed. In such a scenario, what is the standard for determining the impacts as mentioned above? So this question is to the chair. Sir, in your speech, I think you've already talked about the rules.
Okay. If you allow me, I can make it more clear. It has been stated in our Competition Act under Section 21 regarding this combination issue. You see, this is somewhat critical, I would say, because in some country, for combination, they need prior approval from the authority. But in some countries, they need to have permission after merger or acquisition. So now we are at this stage to develop the regulations on merger and acquisition. So yes, you have to be wait for the regulation. We are hopeful that within a very short time, it is in the final stage, our regulation. So after some days that you'll be knowing that what to do if such cases are there. So thanks for your question.
So thank you. For the next question, it came from Jahangirnagar University. I would like to address this to Professor Dr. Enamul Haq, sir. Sir, are you with us? You can hear me?
Yes.
So I think this is more of a from the economic aspect. So the question is, are not competition laws and policies depriving people of getting cheaper deals and quality services of the best company?
No, that is not just cheaper deal is not an issue. Issue is you have a time frame, whether it is today versus tomorrow. So sometimes you sell cheap because you want to kill your competitor and eventually you want to become a monopoly. So my point is that it's not depriving. You have to think about, this is why the issue should be understood. And I think one more thing I should emphasize, and this is, don't compare competition commission with a firefighting institution. We normally think this commission is going to create firefighting. If the price goes up, and they go and put out the fire. The answer is they're supposed to create an environment to maintain competition. That is the most important aspect of competition commission, rather than firefighting on other issues. There is allegation will be there, but throughout the allegation is not just simply punishing one, also creating regulations so that next time it does not happen, creating certainty among investors so that investors can understand what will be there and what will not be there. So I think the idea of commission should always be, I would always urge them not to become a firefighter, rather than become a protector of an environment, of a competitive environment. That should be the role of it. So yes, when price goes down, what is the objective of reducing the price is more important, rather than understanding that price goes down is not is a good thing. I hope I have been able to answer.
So thank you. The next, we'll take two more questions. I think we are running out of time very well. It's been more than 2 hours now. So next question would be to Evan. Evan, are you with us?
Yes, I am.
Okay. So first of all, I'm not too sure if you would agree with this question or rest of the panel speakers will agree or not, but this question comes from the American International University of Bangladesh. And it says, what could be done to bring our competition law in line with international practices? So if I may repeat, what could be done to bring our competition law in line with international practices? So this is something addressed to you, Evan.
Well, honestly, I am not particularly qualified, and especially in a panel like this where there are so many people who are far more qualified to talk about international practices. What I can do is just compare the competition law summarily with US practices. And as I alluded to earlier, I think the biggest difference which jumped out to me, at least as a criminal prosecutor, is the fact that criminal prosecution under the Bangladesh law is limited to violations of the order of the commission. And the sanction, I think, is limited to 1 year. And I believe it was 1 lakh taka, which at least for a corporation would be a fairly de minimis penalty. So, so I think that, I mean, I hesitate to use the terminology "bring it in line with the U.S.," but I would say that that's the biggest difference which jumps out at me. Also, although I think, as Madam Kabir pointed out, there's certainly provisions in the competition law which, with sufficient elucidation, could be used to review mergers and acquisitions prior to permitting them. I think that's much more explicit in US law. There's a definite institutional role for both the Federal Trade Commission and the US Department of Justice's Antitrust Division in reviewing mergers and acquisitions when they are first proposed, because the fear back when this started was that if that authority only kicked in after the monopoly existed, then there wouldn't necessarily be any way to do anything about it. So this pre-review of mergers and acquisitions, I think, is probably what the antitrust division is best known for in the United States today. While there's certainly a lot of other tools for promoting competition, that's the thing that people associate. I think that's what people associate most, certainly with the Justice Department. This, are they going to allow the merger or are they going to fight it? But I defer to my colleagues on how Bangladesh's law stacks up with world standards.
Thank you, Evan.
Mr. Moderator,
Anamulok, sir.
Whether I'm allowed to speak one thing? One question.
Sure.
Before the speakers.
Sure.
Actually, our mandate, the mandate of BCC is not only to regulate the market, it's also to develop the market. One question maybe to my respected speakers, panel speakers, that what may be the advantage of taking prior permission for combination, and or what may be the advantage of taking post-approval of combination if that combination affects on our competition? Would you, someone is response on it?
May I take this question?
This is for my better understanding. Yeah.
Sure.
See, I mean, in case of an abuse of dominance, this is typically, as Professor Inamul Haq said, that is, and Mr. Aslam Hayat also said, ex post facto. Means a competition antitrust breach has already been committed by an enterprise, and that is to be remedied by way of either a penalty or some kind of a direction remedy so that it doesn't occur again. On the contrary, merger control is typically under competition economics is presumed to be a pro-competitive business activity. So if you allow that merger to happen and then you unscramble the omelette back to egg, it's not feasible in economics and in business. So if you have already allowed a merger and then that merger you feel that it is actually not, should have not been allowed, then you are actually looking it into a part of an abuse of dominance. Whereas abuse of dominance is ex post facto, whereas merger is always considered to be ex ante, you are allowing parties to remedy. When they present before you their transactional document, you have a right to make them understand that minimize some of these issues so that we make this approval clear. For example, there can be a joint venture which may be pro-competitive. But if you have allowed that joint venture to continue and then you say, no, I want to break down the joint venture back to their independent parent companies, you are actually ruining the market. You are completely destroying the investment made by the, say, for example, there is a marketing arm of the joint venture and there is a research and development arm of the joint venture. Both of them are coming together to enhance efficiencies in the market. But if you have allowed them and tomorrow you believe that this has to be unscrambled, then you are actually doing harm to the business, to the consumer, to the economy. So a suspension regime, which is worldwide accepted in merger control, has always shown about 95 to 98% approval without any condition, which actually enhances economic efficiency in the market. But if it is a non-suspensory regime, those have not really generated any pro-competitive factors in the market.
So thank you.
Thank you very much. Thank you.
Sir, you want to add more?
No. Yes, okay. Thank you.
So thank you.
Well,
So Professor Dr. Anamulok, sir, you've raised a hand. I've seen this. Would you like to add anything to that?
I think it was the previous question. What was the question? I'm trying to remember now because of that.
Sir, the one.
Oh, just a second. I got it. It's the international law you were talking about. And my flagging is that if you look at the competition laws, even between Europe and America, there is not always they agree on each other. So, defining something as international law is actually the objective behind the law. If you look into the protective regime of the European, they are mostly following social capitalism, the German philosophy, whereas the American has a completely different philosophy. So I think If you look into the international aspect of it, defining something as international is more difficult. I would rather say that, okay, whether our laws should be amended or what is perfect. And obviously, unless there is a regulation, we do have a problem in our environment. In other words, we do not know what we are talking. On the question that the chairman has raised, and I think I agree with Manas Chaudhary there. I would say that, if there is every merger goes into regulation, the Competition Commission, you agree with the merger, and then you see there is an anti-competitive behavior, you're going to give a wrong signal. So the standard strategy always that if there is any complaint or if there is a feeling that this particular merger has a potential for anti-competitive behavior, they normally do come up and say, I would like to look it. Otherwise, I think you behave not as an adjudicator, rather than you behave as a regulator, and I would rather stay away from that.
Thank you, sir.
Thank you
Your
very
answer,
much.
I think, resonated what Mr. Aslam Hayat also mentioned in the two examples he's given in his speech. Sir, one last question you take, and this question actually asked by one of our colleague advocate, and this is, okay, I don't see this question anymore. This was directed to both Barrister Niyat Kabir and Aslam Hayat, and I don't see this question, I think. So it was basically the conflict of laws, but the person who asked the question, he didn't mention what conflict he has referred to, but the question was, how do we deal with conflict of laws? Sir, if you'd like to answer that.
Yes, the reason that you don't see that question is because I tried to answer it by typing an answer. So basically, basically competition law is a mandatory law in Bangladesh. So if there is a violation, you would not apply any other law. You would apply the Bangladeshi law to that problem. And we do not see that this comes into play if there is a product and services. But there is a possibility that such an issue come up in a cyberspace. For example, when Google is an example where it has been questioned by multiple competition authorities worldwide, multiple jurisdictions. And then, of course, they all applied their own mandatory law. So there is a possibility, but that again would be Bangladesh. It would be applying its own law. It's not applying its any other country's law. So that's precisely the answer, unless Nahid Appu has something to add to it.
No, that's a short but very comprehensive answer. Thank you. I think these issues may arise in cross-border transactions. I'm frankly not experienced enough because we haven't had enough cases to really discuss that. But if I can take just 30 seconds to respond to a query that Mr. Hayat had earlier, or a point he raised about exemptions, the power to exempt. Then the original draft of the law, there was an exemption in power, in that the government could, by notification in the official gazette, exempt any goods or services or any class of goods or services or any person or group or class of persons or from the operation of any provisions of the law on such terms and conditions that it may have deemed fit. That provision was not included in the final draft, but the other proviso that sectors and subsectors of goods and services which are not available for private sector participation, we call them the restricted sectors, those shall remain outside the purview of the law. But again, drawing the attention of the chairman to this, that if there is any thought of reviewing the law, the power to grant exemption is going to become important as the application of this law increases. Thank you.
Thank you. We are not going to take any more questions, but I would like to be actually acknowledging the persons who have sent the questions, just spelling the names out. So Didarul Alam from Robi Aziata has asked a question. I think similar question is been answered by Mr. Aslam Hayat. Debabrata Chaudhary, he's the director of legal department, Nestle. He's also asked a question which relates to intellectual property issues. and anti-competitive or unfairness issues. Mr. Kamruzzaman, he's also asked one question. Mr. Azharuddin Bhuiya is a lecturer of Department of Law, University of Professionals, Bangladesh University of Professionals. And also Afroza, she didn't mention her surname. Yes, she's also asked one question. So what we'll do, we'll direct all these questions to the panelists in follow-up emails. So if the panelists can kindly answer or address these questions, we'll be very thankful to them. Since we are running out of time, it's more than 2 hours, 45 minutes now. And we couldn't be humbled and thankful, more than thankful than this, to all these STEM panelists that we, many of us has, I think by now, missed dinner because it's 9:45 in Bangladesh. So before we finish, we'd like to acknowledge few people. Without their help, this couldn't have not been possible. So the esteemed officials from the Competition Commission, including the Honorable Chairman himself, in helping us putting this together, the team of Bangladesh IP Forum, and the person behind the scene who's navigating this Zoom platform, Moimin, Ivy, and also Nuran Chaudhry. So thank you for your kind support. And also our media partner, the Daily, the Business Standard, and the discussion that have taken place today in this webinar. The salient features will be published maybe by next week, and we'd be happy to share it with all the esteemed panelists. It will be published by the Business Standard. They've agreed to do it for us, so we are thankful to them. We also thank JESUP Bangladesh. We also thank ILSA for being wonderful partners, and also my colleagues at the Old Bailey Chambers for helping me out. So once again, before we finish, we would like to thank and be grateful to all the esteemed panelists, starting from Mr. Manas Kumar Chaudhary sir, Mr. Aslam Hayat, Fahim Masroor, Barrister Nihat Kabirappa, and Evan Williams, and Mr. Chairman, Mr. Mofizul Islam. So thank you very much for attending this webinar at until this late hour, and we hope to be with you and work with you again in the coming days. With that note, I would like to conclude the webinar, if I may.
Thank you very much.
Thank you.
Thank you, Mr. Moderator. Finally, BCC has been benefited, So my thanks to the panel speakers and IP Forum of Bangladesh. Yes,
thank you.
Benefited. Thank you, everybody.
We would also like to thank all the guests that they have been very patiently hearing us. So thank you very much. Have a very nice rest of the evening, if I may not say good night.
Thank you.
Yes, from myself, good night.
Thank you. Thanks a lot. It was
Thank you, sir.
very